The House comes to questions for oral answer. The House comes to questions for oral answer, but firstly, yesterday Chris Hipkins raised in the House the issue of ministers clarifying earlier answers to questions on subsequent days. The Right Honourable Winston Peters has also written to me about this matter. Having considered it very carefully overnight, I think they are both absolutely right. An incorrect answer to a question cannot be corrected or modified by way of clarification. I remind members of Speaker's ruling 200(3). A personal explanation can be used about an answer a minister has given. That is always the way in which a misleading reply is cleared up. Speaker's ruling 200(4). The normal course of action as soon as one becomes aware of an error in an oral answer is to take the earliest opportunity to explain. And finally, Speaker's ruling 200(5) makes it clear that a correction to an answer can only be taken by personal explanation. In future, any attempt to correct an answer by way of clarification on a subsequent day will not be acceptable. And I want to thank the members who have raised this issue with me. Point of order, the Honourable Jerry Brownlee.
Mr Speaker, it's my...
Order. If I have an interjection like that again for what is an important matter, I will unfortunately be asking that member to leave. The Honourable Jerry Brownlee.
Noted, noticed. Mr Speaker, Mr Speaker.
Order. I didn't hear the first comment from Mr Brownlee, but I suspect it was not helpful to the order of the House. Can the Minister move immediately to his point of order?
Mr Speaker, I understand that on the 17th of August, it's Tuesday, probably later in the day, the Right Honourable Winston Peters did, as you advised him he should, in the House and lodged a breach of privilege in relation to this particular matter. Such was his insistence that he was right and everyone else was wrong. Mr Speaker, once that letter of privilege was received by you, it should have triggered Speaker's ruling 220(6), which states that the matter of privilege is before the Speaker, and then it is inappropriate for it to be raised in the House in any way whatsoever until the Speaker has made the relevant decision on the matter. So the first question I have is, why did the clerks then allow the question that was repeated on Wednesday? And secondly, why was the privilege letter not received by the Prime Minister's office until after question time on Wednesday?
I will deal with the first point, the second point first. Firstly, I cannot explain why the letter was not received by the Prime Minister's until after question time. That would be a matter for a discussion with the member who has lodged such a letter with me. The letter was received to me just prior to question time on the 17th, I think from memory 12:47. I certainly did not have a chance to look at that letter prior to question time. In reference to Speaker's ruling 220(6), I think the other one that is also relevant is Speaker's ruling 220(5). And on the face of it, on the face of the reading of those two Speaker's rulings, I think Mr Brownlee makes a very reasonable interpretation of those two rulings. But I have spent considerable time looking back as to the reason and the background for those two Speaker's rulings. 220(5) was a ruling that was made by Speaker Wall in 1986. On that occasion, a member had lodged a breach of privilege with the Speaker, and then subsequently that member took the opportunity to attempt to debate it during his debate contribution in the House. Speaker Wall ruled that debate, the mentioning of the breach of privilege was unacceptable and told the member to desist. The second Speaker's ruling, 220(6), is a ruling made in 2011 by Speaker Smith, And on that occasion, a breach of privilege had been raised by a Labor Member of Parliament. Contemporaneously, a colleague of that Labor Member of Parliament sought to also place a notice of motion, a member's notice of motion on the order paper. The Office of the Clerk refused to accept that notice of motion, and consequently Speaker Smith was asked to intervene and did so, and effectively his ruling to 20/6 ruled that a breach of privilege takes precedent over a member's notice of motion. I do conclude by saying that any subsequent airing of such matters that have been raised by a breach of privilege in the House through question time are unlikely to strengthen the final determination I make in finding that there has been a breach of privilege. Point of order. Chris Hipkins.
Can I thank you for your first detailed ruling? And on that second issue that has just been raised, I wanted to test with you the issue of members continuing to question a minister on an issue that they have raised a privilege complaint with you about. Because the issue could well be that they feel the House has been misled, for example, and they have raised a breach of privilege complaint with you. They could continue to question the minister on that topic without referring to the fact that they have made a breach of privilege complaint. The complaint would still be valid based on the facts at the time the complaint was made, even if ministers then give other answers that subsequently contradict it. And I just want to be sure that lodging of a breach of privilege complaint would not then prevent a member continuing to question a minister on the same topic.
And that's exactly what I'm saying. I'm saying that those two speakers' rulings, which you look at them, would indicate that former speakers have made a decision they cannot be debated simply because a breach of privilege has been lodged. When I study the background of them, they weren't an attempt to stop the matter being raised in further questions. And frankly, a member could lodge a breach of privilege, maybe not inform his own caucus colleagues, or maybe not inform other members of an opposition. How would everybody know that a breach of privilege has been lodged? So questions can continue to be asked, but I do remind members of my final comment. If they continue to ask questions, I think in some cases it tends to weaken the case for a breach of privilege ruling finally being made. On a different matter.
It is a very different matter, and I wasn't aware that you were going to be ruling on the other matter, but I want to raise with you an issue regarding a minister's obligation to answer questions, the public interest test obligation that exists within Speaker's rulings for ministers to answer the questions. And the question that the relevant Speaker's ruling, and I had it here a minute ago, but I've been flicking around looking at the other Speaker's rulings that you've been referring to, and I've lost it, but actually I found it again, sorry, it's 193/3, a ruling by Speaker Wilson, lists down some of the matters that could be considered in a minister refusing to answer a question under the public interest, and it is things such as privacy, commercial sensitivity or national security, which sets a reasonably high bar for a minister refusing to answer a question in the public interest. And the question that I want you to give some consideration to, Mr. Speaker, and possibly come back to the House with a further answer, because it does actually cut to the heart of ministerial accountability, is whether the government's communications calendar is a sufficient test of the national interest or the public interest in refusing to answer. And the illustration I'll give you is questions my colleague Jacinda Ardern asked to the Minister of Social Development yesterday about the creation of a Ministry for Vulnerable Children, where the Minister said that no such decisions had been made and that no announcements, and that she was jumping the gun to raise the matter. The Minister then announced that very thing today. That can only have happened if the decisions had earlier been taken, unless there was an emergency cabinet meeting last night to do so. Therefore, the only justification for her not answering the question yesterday could have been the public interest test. And I would put it to you that if ministers can put inconvenience around their communications calendar forward as a public interest test, then they could avoid answering almost any question in the House.
Good point.
I thank the member for his contribution again. I listened carefully to the question and the answer that was given. It clearly wasn't an inaccurate answer. The Minister chose to answer it the way she did, and I am aware of an announcement that's been made within 24 hours of that, I think the Minister's answer will be judged accordingly. I will give further consideration and may come back to the member. The Honourable Jerry Brownlee.
Mr Speaker, I don't want to prolong things today, obviously. The government's got good work to do, and the opposition clearly want answers to some questions by the sound of it. But, Mr Speaker, if you are going to give that consideration, I'd appreciate the opportunity to give our view on that particular issue. I think there are a number of things that could be added to that consideration by yourself and not limited to the annoyance of the opposition.
I would be delighted to hear the view of the Honourable Jerry Brownlee. He is welcome to come and see me any time he likes. We move now to question number one. Question number one in the name of Alistair Scott.